Good morning, ladies and gentlemen. I'm Lyle Denniston from SCOTUSblog.com. I'm delighted to be here. Thank you, Char, for inviting me. The arrangements have been marvelous throughout, and I thoroughly enjoyed this first panel, and I hope you will enjoy ours as well. Because I'm a news reporter, I feel obliged to bring you some news about the court. In the best estimate we have is that John Roberts is writing the opinion in McCutcheon. There are two cases from the October sitting that have not yet been decided. One is McCutcheon, and the other is a case involving Michigan's Proposal 2, which bans affirmative action at the public college level. We believe that Justice Kennedy is writing the Michigan case, and we believe that Chief Justice is writing the McCutcheon case. During the oral argument in this case in October, it seemed apparent that the Chief Justice was reaching for some kind of compromise. And the outlines of that obviously were opaque at the time, but it appeared that the possibility was that they would strike down the 2-year cap on contributions for purposes of candidate donations, but because of what the chief seemed to perceive as a threat to even smaller donors who would want to give to multiple candidates, but after they got past, let's say, the 9th, they couldn't contribute to the 10th. Whether or not the chief can amass 5 votes for that approach, and whether indeed that is what he was reaching for. Let me just say one other thing about that oral argument. What struck me, and Jennifer and I were talking about this earlier, it was really vivid that the 9 justices, none of whom, as you know, has had any prior experience running for public office, are totally naive about how money moves in American politics. The questions that came from the bench revealed an almost astonishing degree of, if you will, innocence, naivete about how money is raised, how money is spent. And so here's an institution that is carrying on the obligation of defining constitutional limits without really understanding what human activity is going on for which they are undertaking to write constitutional rules. I rather had the feeling at the end of that argument that it would have been nice if somebody could have staged a seminar beforehand at which attendance was compulsory for the 9 justices, in which they got a kind of an elementary catechism on who has money, who spends money, how it gets spent, and the responses to it. This is a court that I think really does not understand campaign finance. It is a court, the majority of which is strongly driven by a First Amendment ideological perception that money, at least when money is the mode of expressing one's political ideas, is speech. Whatever qualifications Chiara might say apply to Buckley against Faleo, these people understand that money, when advanced to a political cause, is a form of speech as well as a form of political association, both of which are quite fully and perhaps exuberantly protected by the First Amendment. My panel this morning, 3 distinguished professors, each of whom will make a presentation starting on my far left and coming right down. And our topic is the risk of corruption collides with free speech. If you have any notion of what the word corruption means in the context of campaign finance, you are well ahead of the Supreme Court, because corruption is very much in the eye of the beholder. The same with free speech. We are not sure exactly what free speech is or free association is. But after this a period of time with my 3 colleagues up here, you're going to you're going to understand quite fully those two terms, at least as they presently stand. I will limit my participation. One of the professors on the last panel said that he had a cold and apologized for his voice. I have the voice that I was born with, and that's why I've never been in broadcasting. But when I was in high school, I did undertake to participate in the choir, and every now and then Mrs. Peterson would say, let's stop, and can we try it again without Lyle? So, and I have never overcome that lesson in humility. So humble as I intend to be, I defer first to Professor Gardner. Thank you. And please do write out your questions on the little cards on the table, and the Law Review staff and the students will bring them up to us.
Great, well, thank you. I wanted to begin by first thanking Chara Torres-Spelliscy and Jason Bent, of course, the student editors of the Law Review and the dean, as well as Lyle and my co-panelists. I was certainly honored to be asked to be here, especially because I'm not really an election law person, but rather a labor law person. And so I'm going to focus today on Citizens United, unions, and what I call the First Amendment of labor law. So by this, I'm referring to the disconnect between the Supreme Court's approach in First Amendment cases in the labor context as compared to First Amendment cases concerning the rights of other types of associations, including corporations. So this disconnect was well documented before Citizens United, and I guess you're just going to have to take my word on that, but it manifested in areas like restrictions on union picketing that clearly wouldn't be permissible in the context of other types of associational picketing. And the question then is what Citizens United has to say about that disconnect. So on one hand, Citizens United, as predicted, both increased spending in general and heightened spending disparities, including between unions and corporations, with serious consequences that many of the other speakers today discussed. On the other hand, there's what you might call, or at least might have called in 2010, a potential silver lining for labor, in that Citizens United treated corporations and unions, which were both subject to the challenged provisions of BICRA, equally under a line of First Amendment reasoning that seemed to break down the basis for the worst treatment of unions in other areas of First Amendment law. So in other words, as I wrote shortly after Citizens United came down, it seemed like Citizens United might provide a lever for unions to challenge decades-old restrictions on their speech, not limited to the election context, expanding both what unions are permitted to say and with what money they're permitted to say it. In fact, though, the opposite's happened. In the 4 years since Citizens United, the courts continued to robustly apply Citizens United's line of reasoning in the context of corporate speech, but at the same time, it's not only failed to undermine, but actually magnified its seemingly contradictory treatment of unions. So I want to discuss one specific example of this, which pertains especially to today's topic of money in politics. And that example is Citizens United's treatment of shareholder objectors as compared to its treatment of union objectors in other cases, both before and after Citizens United. So to describe that disconnect, I'll first have to talk a little bit about the Supreme Court's approach to union dissenters pre-Citizens United, sort of its baseline, then Citizens United, then the court's post-Citizens United approach to union dissenters. So in the union context, when I say objectors or dissenters, I'm talking about union-represented workers who would rather not pay union dues or fees. They've got any number of reasons, which range from ideological objections to their union or to unionism in general, to a bare desire not to pay for the union's representation, in other words, to free ride on other workers. At the same time, labor law in the public and private sectors generally require an elected union to fairly represent every worker in the bargaining unit, whether or not that individual worker supports the union. So because individual bargaining unit members can't opt out of union representation and negotiate independently, the National Labor Relations Board and the Supreme Court have imposed on unions a duty of fair representation. But fair representation of workers in a bargaining unit is costly, and so in many American jurisdictions, including my home state of Washington, though not here in Florida, unions can negotiate what are called union security agreements that require represented workers to pay the cost of union representation, though not the union's other costs and expenses, including its political expenses. I'll talk more about that in a minute. This all boils down to sort of four interlocking components. Democratically elected unions who represent all of the workers in the bargaining unit and owe them a duty of fair representation, then they can require represented workers to pay for certain costs of that representation. So in the public sector, these union security agreements implicate the First Amendment rights of the represented workers because they're being required, at least in a financial sense, to associate with the union. Unsurprisingly, then, there's a string of First Amendment cases on the constitutionality under the First Amendment of these union security agreements. And the upshot of these cases is that because of the risk of free riding, which could undermine state government interests in allowing collective bargaining in the first place, union represented workers can be required to pay the cost of core union activities, things like bargaining and grievance administration. But they can't be required to pay for union activities like lobbying or supporting political candidates because the court sees those as both particularly significant infringements of workers' First Amendment rights and superfluous to union representation at individual workplaces. So in other words, long before Citizens United, the First Amendment rule for union objectors was that they can be required to pay for representational activities like bargaining, they can't be required to pay for union politicking. And to enforce that boundary in individual workplaces, the courts created a set of fairly comprehensive requirements that unions must comply with if they want to both collect the fee for representational activities and spend money on politics. Those requirements include things like providing notice of workers' rights to object and pay just the representation fee, a detailed breakdown of the union's calculation of that fee that includes the union's spending on politics in the previous year, placing any disputed funds in escrow, providing an arbitration procedure for resolving payment disputes, and that's all in addition to a judicial forum. So there's one more important thing about the union objector cases. So when protecting objectors, the court balances the objector's First Amendment rights against the government's interest in promoting labor peace through the exclusive representation system. But the court doesn't take into account the union's own First Amendment rights to engage in political speech with money paid by willing members. So in other words, the court views these cases through the eyes of the objectors and not through the eyes of the union that wants to do two things that it's allowed to do. So use willing, dues-paying members' money for politics and collect the representation fee from objectors. So this background, and I realize there was a lot of it, sets up the analogy to the corporate context and shareholders who object to funding corporate political speech, which was one of the issues that the court discussed in Citizens United. So there, the government's argument was that the prohibition on corporate use of general treasury funds on independent political expenditures served a compelling interest because it ensured that only willing shareholders and employees would be funding political speech. So there, the court went about assessing the question quite differently than it had in the union context. So first, the very orientation of the case was different. In Citizens United, the court was looking at the case through the eyes of the plaintiff corporation rather than the objectors. And the court was relatively dismissive of the shareholders, concluding that corporate democracy was an adequate safeguard for them, coupled with the fact that they could, at least theoretically, sell their stock. So in other words, because voice and exit are available, at least theoretically, the interests of dissenting shareholders did not even come close to outweighing the interests of corporations in engaging in corporate political speech. So the argument standing in 2010, post-Citizens United, is that the court's approach in the union context is now outdated. And instead, the analysis should be that unions have associational First Amendment rights, which include avoiding administrative burdens as a consequence of participating in politics. And these rights have to be part of the equation. So the court shouldn't just weigh dissenters' rights against the government interest in labor peace when it's considering union negotiation of these security agreements. So the argument goes that courts should at least reevaluate the procedures designed to protect objectors, balancing objector rights and union rights, both based in the First Amendment. This wouldn't mean that unions would be totally free to use public sector objectors' money for political speech, but it would mean that the procedural scaffolding that protects objectors would have to at least be reevaluated. Instead of the current procedure, the results might come out closer to sort of a good faith standard, subject to reimbursement, something like that. But this isn't how it's played out. Instead, after Citizens United, the courts continued to strengthen corporate and associational rights, for example, holding that the sale of certain information about doctors' prescribing practices was speech. But the courts exacerbated the tension in the union context by strengthening protections for dissenters, the opposite of the approach that Citizens United seems to compel in a case called Knox v. SEIU Local 1000. So in Knox, the court considered a First Amendment challenge to a mid-year union dues increase, and specifically to the fact that SEIU had not given public sector employees an additional opportunity to opt out of paying for union political speech. So like in the pre-Citizens United cases, the Knox court focused only on the rights of objectors, ignoring the union First Amendment rights that were also implicated in the case. The court didn't even discuss this aspect of Citizens United. Instead, the court reverted to looking at the case only through the eyes of the objectors, if anything becoming increasingly concerned, not just about ideological objectors, but about the First Amendment rights of represented workers who just hadn't cared enough to complete the opt-out process. So this led the court to widen the incongruity between Citizens United and the law of union objectors by requiring unions assessing mid-year dues increases to obtain affirmative consent by employees rather than requiring objectors to opt out, right? So the court goes from an opt-out to an opt-in. Of course, one consequence in switching from an opt-out default to an opt-in default is that a different set of workers who fail to make an affirmative choice will be potentially harmed. So now, workers who would prefer to help fund political speech through their unions, but who neglect to opt in, will actually be deterred from engaging in that First Amendment activity. And Knox may not be the end. This term, the court heard Harris v. Quinn, another public sector union fees case. In Harris, the plaintiffs have asked the court to hold that public sector unions can't charge for representation services at all. While this is a slightly different First Amendment issue, it will nonetheless have an impact on unions' abilities to effectively aggregate worker voices in politics if the plaintiffs win, right, further contributing to this imbalance between corporations and unions. Finally, I wanted to just briefly discuss union reactions to Citizens United. In other words, did unions themselves regard Citizens United's removal of restrictions on their ability to spend in politics as a net positive, either for its own sake or because of these potential ripples in other areas of First Amendment law? In a word, the answer is no. So immediately after the decision, the SEIU called for a constitutional amendment to overturn Citizens United. Since then, the AFL-CIO has done the same. Nonetheless, they both apparently concluded that they can't ignore Citizens United, as well as the later DC Circuit case authorizing the super PAC. And so in the 2010 and 2012 election cycles, unions both contributed to super PACs that weren't related to the labor movement, like Priorities USA Action, and they created their own super PACs. For example, the AFL-CIO sponsored Workers' Voice super PAC spent a little over $6 million. Interestingly, much of the money raised by the Workers' Voice super PAC was devoted to targeted door-to-door canvassing of non-union workers, often by volunteers. In other words, instead of massive advertising buys, though some other union super PACs did that kind of thing, Workers' Voice funded millions of conversations about the upcoming election, especially in places like Ohio and Wisconsin, where then recent attempts at public sector labor law reform, successful in Wisconsin, not in Ohio, had mobilized union members and supporters. So in conclusion, the post-Citizens United landscape is one in which unions are increasingly disadvantaged by First Amendment law in their relative abilities to engage in political speech. And it's possible the disparity will increase because of this term's Harris decision. And so if we believe that I do, that unions and the workers they represent are an important voice in politics, then it's reason for concern. Thank you.
Good morning. I'd like to thank Professor Torres Spelcy, Professor Bent, the Law Review, my co-panelists, Ms. Denniston, for coming down here. I'd like for you to a minute for just imagine two politicians. My first politician, let's call her Good Eve. She's running for Congress. She tells a group of students and parents of students that she supports legislation to subsidize student loans, but she needs money to get elected. She says that once she's elected, she's going to propose legislation to subsidize these student loans, and she's going to convince other legislatures to vote in favor of it. She asked the students and the parents to donate to her campaign, and they do, and she gets elected. And the first thing she does in office is she proposes this new legislation to subsidize student loans. My question to you is, did Good Eve commit a crime? My second politician, I'm going to call her Evil Eve. She's running for city mayor. She tells a contractor who presently does business with the city that if he donates money to her campaign, that she's going to make certain that his company gets the contract with the city. The contractor donates the money, Evil Eve gets elected, and the first thing she does is she gives that contract to the contractor. Did Evil Eve commit a crime? Are these two individuals really any different? Both are acting and asking for campaign contributions. Both are saying that they will do an explicit act if elected. Good Eve's act seems like the kind of act a politician should do, legislate. And the constituents are donating because they support that politician and what she stands for. On the other hand, Evil Eve's act is a little bit more focused, with a contractor securing a benefit. But both constituents, the students and the parents and the contractor, are all going to receive benefits by the acts of the politician that they contribute to. Now let me ask you this. Will it make a difference if Good Eve fails to report the campaign funds she received on her campaign finance forms or on her taxes? And will it make a difference if Evil Eve does report these funds on her campaign forms and taxes? And will it make a difference if Good Eve, when elected, lives a life of luxury and is often seen in clothes and jewelry that was given to her as gifts by friends and constituents? And what if Evil Eve becomes an outstanding mayor who brings new programs, new businesses, new money to her constituents, and lives a very simple life, donating and contributing much of her income back to the city? The line between good and evil is getting blurred. There's a growing number of cases that present the issue of where is the line between an acceptable campaign contribution and criminal conduct? Or as some would put it, is it a campaign contribution to candidates because they support their position, or is this just sophisticated corruption? But when the money or a gift is given in exchange for a specific vote, specific legislation, specific contract award, or some specific action, it may rise to the level of being a quid pro quo, and it may be the basis for the candidate being charged or convicted of criminal conduct. Questions can arise as to whether it is a campaign contribution and whether the corruption laws should treat this conduct differently depending upon whether it's a campaign contribution or a gift. Equally problematic is the evidence that is being used surrounding the presentation of the case. What may seem clear in the law becomes questionable when you factor in that the politician received a Louis Vuitton purse, tickets to the U.S. Tennis Open, or a golf game in Scotland. I'm not going to talk today about the aftermath of Citizens United, and how corporate spending is now masked and lacking transparency. I leave that for all the others on my panelists here to discuss and expound upon. Instead, I'm going to focus on what happens when you have fuzzy corruption laws that pertain to campaign contributions, how extraneous conduct can influence the setting, and how a lack of transparency in the system creates both prosecution and defense problems. So let me start by looking at some of the key corruption laws that have bubbled to the surface with respect to campaign contributions, and also some recent cases related to bribery-type conduct, where a defendant politician is charged with criminal conduct, and they argue that the money or the gifts received were legitimate campaign contribution. Then I'm going to speak about the blurred line between legitimate campaign contributions and corrupt conduct, and why this needs to be revisited. I call for a revamping of our criminal corruption laws as they relate to contributions, and specifically campaign contributions, to provide more clarity. Congress needs a redo of these laws. I also stress the importance of invigorating and empowering our regulatory process. How many regulatory nightmares do we need in a post-Bernie Madoff world to recognize that something needs to be done? Finally, I discuss the benefits for the prosecution and defense of campaign-related conduct being transparent. There are several criminal statutes that can be used to charge individuals with corruption related to political office. I'm focusing here on statutes where allegations have been made that the charge or conviction is unfounded because the monies received were legitimate campaign contributions. This argument arises in the context of cases using the Extortion or Hobbs Act, bribery, federal programs bribery, mail-in wire fraud, honest services fraud through mail-in wire fraud, as well as other charges such as conflicts of interest. Prosecutors have ample charging choices. As a matter of fact, they have so many charging choices and discretion that often they're charging multiple crimes for the same conduct. The classic statutes that I focus on are extortion and bribery. Hobbs Act, or extortion in the white-collar context of campaign contributions, is when one obtains property under the color of official right. Outside the white-collar crime context, under color of official right doesn't play a part. It's robbery or violence. What constitutes under color of official right in the campaign context has been the subject of several Supreme Court decisions. The Supreme Court, in a case called United States, McCormick versus United States, a 1991 decision, tackled the case of a West Virginia House of Delegates member who had been charged with 5 counts of Hobbs Act violation, and also a count of filing a false tax return. The court noted that he represented an area of the country that was in need of doctors. There was a shortage of doctors, and that he was a leading advocate and supporter of a program that allowed foreign medical school students and graduates to practice under temporary permits while studying for their state licensing exams. The criminal charges arose because he allegedly took money from these doctors while sponsoring legislation that would exempt foreign medical graduates with significant work experience from having to take the state licensing exams. Basically, he allegedly took money and did not report this money on his campaign forms, and also failed to report it on his tax return. The Supreme Court reversed the convictions because there was no showing that there was a quid pro quo for the money taken. The bottom line was the Supreme Court recognized that political contributions are different. The next year, the Supreme Court took the case of Evans versus United States, a case involving a county commissioner who took money, $8,000 from an undercover agent. He reported the $1,000 check on his campaign contribution form, but he did not report the $7,000 cash. Again, in a case involving the Hobbs Act, and again involving a statute using the language under color of official right, Evans was convicted. This time, the Supreme Court reaffirmed that a quid pro quo was necessary for a Hobbs Act violation, but they said this time that because there was a passive acceptance of the benefit by a public official, it would meet the test of the Hobbs Act. The court stated the government needed only show that a public official has obtained a payment to which he was not entitled, knowing that the payment was made in return for official acts. Many lower courts have followed these Supreme Court cases, and several issues continue to predominate the landscape. Should a quid pro quo be used only in cases involving campaign contributions? What level of proof is needed to establish a quid pro quo? Should the requirement of a quid pro quo be used outside the context of the Hobbs Act in cases such as mail fraud and honest services? Although prosecutors favor the Hobbs Act because it carries a sentence of 20 years, where bribery only carries a sentence of 15 years and gratuity is only 2 years, bribery requires the government to prove that something of value was given, promised, or offered to a federal public official corruptly to influence an official act. Now, the government has indicted many individuals, and the indictments against politicians are sometimes written in storybook fashion for the press to get the full flavor of the government's belief that there was corruption. So, for example, the governor of Virginia, Robert McDonald, who was recently indicted, faces charges of conspiracy to commit honest services mail fraud, wire fraud, conspiracy to obtain property under color of official right, the Hobbs Act, and in addition to that, not only the conspiracy, but the underlying charge of the Hobbs Act, false statements and obstruction of justice. There's a forfeiture notice attached to the indictment, and it reads like a list from a designer's wardrobe selection. 2 Oscar de la Renta dresses, 1 royal blue Peter Miller golf shirt, 1 Sun Mountain Notre Dame golf bag, Louis Vuitton shoes, white, black, just to name a few of the items that are listed. If there is a pay-to-play scheme, one is likely to find that the government will have an indictment with as many possible charges as they can find. They throw the spaghetti at the wall, and they hope that something sticks. And in many cases, that happens. Certainly, after an indictment is written for the press, allegations that paint, or shall I say, taint, the picture that money and gifts were taken, a perp walk that parades the politician before the cameras as opposed to having the individual just surrender, the defense starts 3 steps behind the prosecution, even before that trial begins. But let's get back to the statutes. And the fact that we're talking about getting money, in some cases, as a legitimate campaign contribution, and in other cases, as an extortion or bribery conduct. You need to have this quid pro quo, and it must be clear and it must be unambiguous. But in the case of United States versus Seligman, the 11th Circuit stated there is no requirement that this agreement be memorialized in writing, or even, as the defendant suggests, be overheard by a third party. Since the agreement is for some specific action or inaction, The agreement must be explicit, but there is no requirement that it be express. From an advocacy perspective, it would seem easier to convince a jury of guilt when you have a cash payment to the politician as opposed to a check. When you have failure to report the money on the campaign forms, or when you have a failure to pay taxes. It's kind of like having a Swiss bank account. People hear it's a Swiss bank account, and they're quick to surmise some nefarious intent. What rises to the level of a quid pro quo is unclear, especially when the standard is fuzzy and the cases are left to be decided by juries on extraneous factors like the Louis Vuitton bags or tax charge, and not on whether the campaign contribution crossed the line. The conduct between good Eve and evil Eve becomes nebulous at best. Or maybe it would rest on the type of legislation being presented. If it's a gambling statute or perhaps a city's laws on lap dancing, the campaign contribution might be suspect. In a recent decision, the Ninth Circuit case upheld a Hobbs Act conviction of a city council member for soliciting campaign contributions in exchange for sponsoring legislation to relax the city's laws on lap dancing at the Contributors Club, stating, "How then, in the potentially polluted atmosphere of campaign contributions, can we tell a criminal agreement from a large campaign contribution accepted from a contributor who expects favorable results?" The Supreme Court's answer lies in the level of explicitness. And there's so much more confusion on the laws than I can even mention. My hypos of Good Eve and Evil Eve had them asking both for campaign contributions. They solicited it. But what if the money is just given to them and they passively accept it? And do the bribor and the bribee have to agree? Is a mere promise to act on legislation sufficient? Couple this confusion with the lack of transparency in the election realm today, and you have problems. It may become a problem for the government in that they have to get the evidence to prove the crimes. With less disclosure, the tie between the money and the specific act may be more difficult to find. The government may have less ability to subpoena the appropriate documents. The problem from the defense side is that the politician needs due process rights of knowing what is criminal and what is legal conduct. But the problem is more systemic than stated here. Like in so many areas of criminal law today, the government is quick to jump in the criminal realm as opposed to trying to rectify the improprieties through regulation and administrative processes. Perhaps if our taxpayer funds were being used to scrutinize campaign reporting as it relates to those who reap benefits from the donated funds, as opposed to running an undercover operation for $7,000 in cash for a county real estate deal, we might catch the sophisticated corruption. Perhaps if we had more transparency, both prosecutors and government officials, potential defendants, would also have a better system. Thank you.
Thank you. I love looking out on all these state flags. I don't know if anybody in the audience has noticed, but your state or states are all represented. What a beautiful conference, and I've already learned so much from everybody here on this morning's panel. Thank you. Thank you, Ellen. Ellen and I agree far more than she knows. I'll just tell you broadly how I think about these things, and then
turn to my own wandering into white-collar criminal law and how it relates to Citizens United. I think about it as there's basically two kinds of anti-corruption laws. There's broad prophylactic laws, like the secret ballot, which is an anti-corruption law that makes it really hard to bribe people for their vote. Or you can't name a candidate within 30 days, a corporation can't name a candidate within 30 days of an election. Then there's the other kind of motive kind of anti-corruption law that investigates the soul of the people involved. Very broadly, what I think the court has been doing is pushing us away from those prophylactic laws, which I think are the best part of our nation's history, and pushing us towards the swamp that Ellen is describing by making it harder to pass campaign finance rules or other rules. Prosecutors then move to these complicated realms where, besides the risks that she was talking about, there's also risks of racial and political prejudice along with the prosecutor's discretion. So I want to start with my favorite early prophylactic law. In 1785, Benjamin Franklin, the most corrupt of old men, as Arthur Lee called him, was leaving Paris and was given a ruddy-faced portrait of King Louis XVI with diamonds in 2 sets around the portrait. There was some consternation about that. He was not allowed to keep this snuff box from the king. It was a little box without first going through approval of the then Articles of Confederation because of a peculiar feature of the Articles of Confederation, which we had borrowed from the Netherlands, a feature that says no person holding an office can accept any gift from any foreign king or state. The Netherlands, actually, people made fun of it. An international scholar in the 17th century said, what do they think they're doing, trying to create Plato's Republic in the marshes and fens of their country? But it was this very strict rule that we adopted as an early rule saying no gift may be accepted because we as an early country had a belief that these bright line rules banning gifts, not investigating the soul of Franklin, but bright line rules banning gifts were actually very important for protecting against corruption in the young republic. When the I think it was in Virginia, debates on the Constitution, this provision remained. It still exists in our Constitution, Article 1, Section 9. No gift of any kind whatever may be accepted without going through congressional approval. In the Virginia House, they discussed it and said, what's this doing here? And they said, well, a box was given to an important person from one of our allies, and it was thought important to protect against corruption and also the sort of sense of corruption that we create some laws to restrict against that. So skip forward 214 years. There is another diamond. That was a diamond-encrusted snuff box. This is Sun Diamond Growers. Sun Diamond Growers was a agricultural cooperative, and it had 2 things it was very interested in. Secretary of Agriculture Mike Espy at the time was considering 2 different rules. One which would designate small-sized entities that could get basically subsidies for their international marketing. Sun Diamond Growers was full of many small-sized entities, such as Sun-Maid Growers of California, Hazelnut Growers of Oregon. These are not small-sized entities necessarily, or as the district court said, hardly mom-and-pop operations. But they were, arguably middle, so they wanted to be designated as small-sized entities. And Secretary of Agriculture Mike Espy was also considering pesticide regulation. So, Richard Douglas, Vice President of Corporate Affairs for Sun Diamond, gave Espy tickets to the U.S. Open tennis tournament. He gave him luggage worth $2,500, $665 in meals, and then my favorite is a framed print and a crystal bowl. So, prosecuted under the federal gratuity statute, which is, it's called the federal gratuity statute, although it's technically a subset of the federal bribery law. And there was no evidence that there was any implicit deal going on. There was no evidence that Douglas said to SB, here's your tickets, here's what we want, or even had a softer conversation about the connection between those two. And the government said there didn't need to be. According to the government, the Sun Diamond violated the statute by giving gifts to curry favor. Sun Diamond appealed, and the Supreme Court sided with Sun Diamond and against most courts of appeals, holding that the government had to prove a nexus between the crystal bowl and the pesticide regulation. Now, my take, and of course I'm interested in Ellen's thoughts on this, is that it was a plausible reading of the statute, the Supreme Court's decision. It's a troubling one because it's difficult to see how it makes sense of the gratuity statute. The gratuity statute seems to contemplate that it would be a violation to give gifts in advance of governmental action. It makes it very, very hard to prosecute under the gratuity statute before anything has been done, because SB hasn't done anything. So you give a gift, Secretary of Agriculture has 1,000 different things he could do. It's very difficult to prove a nexus. As many people have noted afterwards, Sun Diamond effectively turned a bright line, prophylactic rule into something a lot more like the federal bribery statute that requires one to look into the particulars of the motive and interaction. So it's technically a matter of statutory interpretation, the Sun Diamond case, and Leahy has offered a bill to overturn it, but I think it's a really important case. It's 1999 for the deep logic of politics that it presents, and I think we see that again then in Citizens United. It shows a real lack of understanding, as Lyle was talking about how gifts and influence actually work in the political system, and how difficult it is to find those nexuses if what you're concerned about is influence. Justice Scalia, in fact, calls the opposite reading of the rule that most courts of appeal had talked about, an absurdity. So he's a little bit like the Dutch writer in the 17th century, sort of making fun of the Netherlands. He's saying, you can't have a strict gift rule because it would lead to criminalizing a complimentary lunch for the Secretary of Agriculture given by Sun Diamond. Apparently, Justice Scalia had never heard there ain't no such thing as a free lunch. So he outright rejected the argument that the statute could criminalize buying favor or generalized goodwill. He rejected the argument that the statute could criminalize the desire to acts that were motivated to shape the Agriculture Secretary's actions without any particular nexus. So if you read the case as political theory instead of statutory interpretation, it seems that the court either thinks that money can't influence power, or that its use of money to influence power in this way is inevitable and not troubling. In fact, it is worthy of mockery to suggest otherwise. So we come forward a few years to the next Bright Line rule in Citizens United. Most of you know the case very well. On its face, of course, it's not the same as Sun Diamond at all. But what you see is the temptation to turn all anti-corruption laws into one law, which is a bribery law that requires a nexus. So in oral argument, Ted Olson argued that there was no justification for the law, no corruption justification for the law, because there was no evidence of a quid pro quo there, and if there was, it would be punishable by a crime. It's a really powerful argument that the only kind of law, Olson was saying, that is a legitimate anti-corruption law is a quid pro quo law, basically is a traditional bribery law. I'm not going to address the speech part, but just to review, when the court struck down the Bright Line corporate spending rules in Citizens United. It was rested on two determinations. First, that the First Amendment protects speech regardless of the identity of the speaker. And second, that there is no important countervailing interest served by this ban. Corruption, it held, is the only permissible countervailing interest. And therefore, if anti-corruption interests weren't served, the law had to fall, and then it defined corruption in a very particular way. As a matter of law, corruption means only quid pro quo corruption. And quid pro quo only exists, if you read Kennedy's citations and ellipses all tacked together, when there is a direct example of votes being exchanged for expenditures. How am I doing on time? Okay. So I'll say what he does. He says corruption is not, as a matter of law, and this actually again relates to Lyle's point, is that these are not questions of fact about what actually happens in the world. These are determinations, abstract determinations of law about what corruption means. It does not include influence. It does not include ingratiation or access. It does not, as a matter of law, include the corrosive and distorting effects of immense aggregation of wealth. And as a matter of law, and this is actually the most extraordinary one, not as a matter of fact or context, as a matter of law, independent expenditures by corporations do not give rise to corruption. So, what does give rise to corruption is quid pro quo. So, where does this come from? Clarence Thomas has long time been arguing that corruption is just quid pro quo. It means nothing but financial quid pro quo, dollars for political favors. In 2000, he said, what are you trying to do? Separate corruption from its quid pro quo roots? In 2002, Kennedy sort of is pushing this along. What they're doing, I want to talk about sort of 2 or 3 different problems with this quid pro quo definition. Not engaging, where Ellen and I think disagree probably on what another definition is. I think there's a lot that's difficult in Citizens United. I disagree with most of what he did. I think there's difficult questions of speech, and I think there's difficult questions of press. But I think the definition of corruption as quid pro quo is untenable as a matter of history and involves a basic category mistake. So what the court does is it takes a concept, corruption, and then tries to define it by reference to a criminal law term as instantiated and as interpreted by courts. It's a very weird kind of category mistake. It's like trying to interpret the Equal Protection Clause by an equal protection law that Congress passed or that the states passed. There's a sort of, that's mistake one. A part of that mistake is a basic mistake of positivism, the idea that law is only that which exists in positive law written down in statutes, which just doesn't work for the concept of corruption. It doesn't work for a few reasons. One is if corruption law, the concept of corruption is dependent on laws that are passed naming behavior corrupt, the most corrupt countries in the world have no corruption. So in early 18th century, there were no bribery laws. There was no law against bribing legislators. So if you're a positivist, if you want to define corruption by relationship to laws in statutes, it wasn't corrupt to bribe legislators in 1790. So that's mistake one. Mistake two is it creates a really weird circular task for justices trying to determine whether laws serve anti-corruption interests, because the anti-corruption interests are being defined in the law they're trying to serve. So inasmuch as BICRA is an anti-corruption act, shouldn't the justices then refer to that definition of corruption, an expansive one, in interpreting corruption? Minor but serious rhetorical intellectual mistake in corruption. But thirdly, it doesn't work for quid pro quo. So quid pro quo comes from Latin, comes from this for that. Its historical usage is in contracts, meaning in that context to the relative equality of exchange. So here's what's weird. Buckley mentions quid pro quo, but Buckley actually creates quid pro quo as a criminal bribery term. Before the 1970s, there's almost no mention of quid pro quo in criminal law. 58 times total before 1976, doing my Westlaw research. And almost every single time the phrase quid pro quo is mentioned before Buckley, it's in reference to relative equality of exchange, not in reference to this idea of nexus. So after the 1970s, so first it isn't historical. Second, instead what you see is Buckley picks it up and other courts start taking it as part of their definition. So campaign finance law then injects its way into white-collar criminal bribery law. But even since Buckley, its use hasn't been consistent. So the court, one, thinks it can define it by reference to the statutes, which it can't. Two, thinks it can define it by reference to history, which it can't. And three, thinks it's got its hand on something really concrete and specific, unlike this nebulous anti-corruption principle that people like Professor Lessig and I talk about. We've got something specific. It sounds Latinate. It must be specific. But as Ellen did just a magnificent job of showing, the meaning of quid pro quo itself is entirely inconsistent. First of all, most state statutes don't require it. Some do. Arizona's bribery statute has no quid pro quo. Ohio doesn't use quid pro quo. Alabama doesn't use it. Michigan doesn't use it. Some states do, but there's no consistency. There's no sort of deep connection between quid pro quo and bribery. And when it's used, as my favorite quip is from the Sixth Circuit, it means entirely different things. Sometimes it means something specific in exchange for some specific governmental action. So I give you this in return for SB. I give you a crystal ball and SB give me pesticide regulation. But sometimes it means something less. It can mean in the Second Circuit, gift in exchange for helping me out as opportunities arise. This is the as opportunities arise quid pro quo. As the Sixth Circuit said, not all quid pro quos are made of the same stuff. So it's true that some statutes have been determined to require it, but we don't know what it is. So this search for definiteness has actually led to more turtles than all the way down than the court ever thought it did. And the fact that these fields, this is why I love this panel, these fields exist in splendid isolation each from the other, allows the court to refer to this, this technical sounding thing, quid pro quo, in the campaign finance context, whereas those in white-collar criminal bribery know it doesn't have that technical power. So, two things. One is, just to conclude, one thing I want to keep watching, and I think we'll see it as Ellen's cases come up, is to watch for what the court is doing in the corruption context. I think they're trying to make all laws the same law. They're trying to make them all criminal bribery laws. They have a vision of what a criminal bribery law is, which requires nexus, and I think they're going to continue to require more and more of relatively explicit exchange, sort of a kind of contract. So just moving towards turning all anti-corruption laws into the same law, whether it's the Hobbs Act, the mail fraud statute, the gratuity statute, or something else. Maybe differences in the margin. Second, exhortation. The difficulty in what that will mean is that the only people who can be prosecuted under anti-corruption laws are the buffoons, are those who foolishly create something like a contract or are overheard. And maybe that's okay. Maybe we should limit that in the white-collar bribery context, because there is great danger in using criminal bribery prosecutions as political tools. However, that makes all the more important the kind of bright-line laws that don't look at motive, that are just, you can't give more than $2,000. You can't mention somebody's name within 30 days of an election, because only those, like the snuff box rule, can really protect us from the kind of influences that are so dangerous.
There you go. We have some questions coming from the audience, but as they're coming up, if they are, would any of you like to comment on each other's presentation? Ellen?
Sure. I'll comment very briefly. I agree.
My only comment, I really appreciated, Charlotte, your presentation. We haven't talked about speech at all. And I think what it shows is that there's an idea that the court itself encourages, that it's a free speech court. But there are real inconsistencies with the way in which speech is treated in different contexts. And I think that again suggests that what's really happening here is ideological and a vision of politics and what politics is and what politics should look like, as opposed to a vision of speech qua speech.
Yes, I think it's interesting to look at how the court views the adoption of public sector union statutes, or at least how some members of the court view that. So in Harris v. Quinn, this case from this term, where the court is looking at revisit the constitutionality of the agency fee agreement, full stop, in the public sector context. The oral argument was fascinating because they were reviewing this Illinois statute that allows a new group of workers, these home health aides who are Medicaid funded, to join a union. And it was completely up to the state to decide, in the state's view, it was up to the state to decide whether or not to allow these workers to unionize. And then the state was the employer that was bargaining with them. And so for some of the justices, it just seems totally unfathomable that any employer, including a state employer, would voluntarily agree to subject itself to having a unionized workforce. And so they say, well, there must have been some corruption there, right? And, it didn't help that this law came into place under Governor Blagojevich, who, of course, brings some baggage with him, but it's an interesting, not quite exception, but...
No, it's not an exception. You'll find this everywhere. This is a little hobby horse I'm on right now is the Takings Clause. So in the Takings Clause, the court feels incredible power and authority to review the corruptness of legislation directly. So the court actually feels, I think it's sort of a disdain for democratic politics, the sense that all democratic politics is corrupt, so we have to review it. But we don't want to allow Congress to pass laws to limit that corruption.
Let's give our audience a chance to put some questions. This was directed to Professors Podger and Teachout. So what would be a principled way to distinguish bribery or extortion from lawful campaign issues to a candidate platform one supports? A distinction between bribery, extortion, and lawful campaign.
So if I wasn't entirely clear, I think the way to make the distinction is just to make a bright line rule. Say you can't give more than $500, you can't give more than $1,000. You can't spend in this context. So that is the best way, except for the most extreme case, is that juries shouldn't be in that business. That's a congressional before the fact determination of what kinds of things. Second, we've never created a system of campaign finance. We have only outlawed a series of systems. We've outlawed spoils, and we've outlawed corporate donations, and we've outlawed, tried to outlaw some corporate spending. But the best way to get outside of that is actually to create a system of campaign finance that actively supports candidates, so they don't need to be in those situations.
I'd go one step further, and I'd say take it out of the criminal context, even further than that, and have it as much more of a regulatory process. So have actual limits on spending, have transparency in the system so that you can see if somebody is not abiding by it. That's going to hurt them more. The press will bring that out. If you have the transparency, it can correct itself. The other problem I see is there's a conflation of Hobbs Act and bribery, and gratuities for that matter too. They're separate crimes. And once you put them in the campaign context, you see them all of a sudden becoming the same. It's one of the few times I agree with Justice Thomas when he stated in the Evans case that what is the difference basically between Hobbs Act and bribery anymore? It really has become you have the quid pro quo and that's it. So I think that separating these crimes out, one has a 20-year max, one a 15, and one a 2-year max. They're pretty different, and they have separate elements to the crimes. And to start making them and interpreting the same just because of the quid pro quo, I think is not a proper way to go. We should stick to criminal law. Take this out of criminal law. I don't belong here.
This is directed to anybody. Why do you think the fact that unions have required disclosure and the ability to object to political spending doesn't permeate the debate? The GOP consistently says unions don't have to disclose, but they do. correct?
True, yes. Yeah, and even more than that, there was a distinct sort of strain of commentary after Citizens United and then after the last election that said unions are actually advantaged relative to corporations under Citizens United because they can get all their people out canvassing. So, whereas we, poor corporations, are stuck with massive media ad buys, you unions get to ask your members to go door knocking. And, while I do sort of prefer door knocking as from a normative standpoint, as a political strategy, I'm not entirely sure that is a fair comparison. I think it's one thing is I think it's sort of lack of public understanding about how unions operate today, right? Union density in the United States has fallen to about 12%, right? But that doesn't reflect the variation in states. So my home state has union density of about 18%, New York has like 25%, but North Carolina has 2 or 3%. So in some states, nobody knows anything about unions from personal experience. All they know is what they hear about in the media, right? Which is that unions don't have to disclose and
Here's another from our audience. Does the Supreme Court have a double standard for the First Amendment for corporations and for unions? And if so, is there a good reason for
it. Well, yes. I think the answer is no, there's not a great reason. And one thing I would say about that is that if you look at some of the union cases about, for example, union picketing that's prohibited by the National Labor Relations Act, the court doesn't do a great job of explaining what standard of review it's applying. It just sort of says, labor law prohibits this picketing. We think it seems unfair to businesses or to employers, so we're going to uphold the act. The court doesn't, for example, say we're applying the commercial speech test. The court doesn't say we're applying strict scrutiny. The court doesn't even say we're applying some special union rule. It just sort of proceeds. And then that sort of gets enshrined in the law over the course of many decisions, and we sort of end up being stuck with it, it seems.
I'm going to abbreviate this question. It's quite long, but is mandating political contribution disclosure the only way to be able to identify if quid pro quo is going on? Are there other remedies?
There are. There are certainly, you can do an undercover operation.
That's happening.
It does, and you can have stings. I remember Abscam, and there are a lot of different ways that you can get the evidence. You can use wiretaps. There's all kinds of different ways that the government can spend money to try to do what would easily be done if we had transparency.
I just want to say, I want to just persist in this a little bit. I do think that quid pro quo is sort of a fantasy, that actually how power works is much softer than that. You don't ever see this kind of contract law relationship between sophisticated players.
Well, let me just make one comment, privilege of the moderator. If you're ideologically driven to expand the concept of political speech through expenditure of funds, you have to find a way by which you diminish the corruption concept as an impediment to speech. So if the only way to do that is to reach into some strained concept of the criminal law, that's what the agenda tells you to do. Because first of all, you open your eyes in the morning if you're Tony Kennedy, and you say, I want more speech, because I believe that more speech is the better corrective for flawed speech. So if you start with that as your opening cultural value, then it is in your distinct interest to try to remove all of the impediments to speech. And so Kennedy obviously has been laboring in this vineyard ever since Austin versus Chamber of Commerce. And he now has a clear majority of the court, so that almost any time that you see now some restriction on speech, you're going to find the court hostile to it. For example, the court struck down a federal statute that made it a crime to depict animal cruelty. The court struck down a federal statute that made it a crime to distribute video violence, violent video games. The court struck down a statute that limited the kind of protests that you could stage at funerals. And so the progress goes on that this is distinctly a First Amendment court. And so I think the panel is really quite on point in saying that the court does not understand what it's talking about when it deals with corruption, but it is using corruption only as a make-weight in order to serve the First Amendment agenda, I think. This is a very discrete question, and anybody can take it if they feel up to it. Can you talk about the Foreign Corrupt Practices Act and what we can import from that into the domestic sphere? Is anyone up to that one?
I'm happy to do that one because it's actually kind of fascinating because the Foreign Corrupt Practices Act was passed and sort of came out of the Watergate hearings. And in the Watergate hearings, what was disclosed was this massive amount of money or this corruption that was occurring where corporations were paying bribes to individuals to get contracts and whatever in foreign countries. And so they passed the Foreign Corrupt Practices Act. It ended up that businesses, there was an outcry from businesses at the time it was passed because it was constraining the U.S. ability to have an equal sort of balance in the corporate sphere internationally. And so they started putting in some provisions within the Foreign Corrupt Practices Act of grease payments and other provisions that you could, in fact, give certain things if it was a routine government matter. In other words, you had to pay a fee. And what's happened in the long run is there have been a few cases recently dealing with the Foreign Corrupt Practices Act. In many instances, we're seeing there are plea agreements. In instances that have gone to trial, the government has been very unsuccessful. As a matter of fact, on my White Collar Crime blog, one of the jokes I put in one year was, what is I think the last thing you'll possibly see is a conviction in a Foreign Corrupt Practices Act case, because it just is not happening.
We are just about out of time, but let me conclude with one other remedy, direct political action, and we saw it in the court on Wednesday morning. The court was in the midst of two cases arguing over attorney's fees in the trademark context. And the Chief Justice said to one counsel, counsel, you have 3 minutes for rebuttal. At that point, a fellow from Los Angeles stood up in the back of the courtroom, well-dressed, entirely appropriate appearance for being in the court, and said the following: corporations are not people. Money is not speech. Overrule Citizens United. So it did interrupt the proceedings momentarily, though the chief acted as if nothing at all had happened. The police were on this fellow in a trice, and he was arrested, and he has been charged with engaging in an oration or harangue inside the Supreme Court building. One of the things that we're saying in the press room is obviously that statute does not apply to anybody who sits on the bench. Thank you for your attention. We are out of time.